So my name is Stephen Shrybman. I'm a partner at Sack-Goldblatt Mitchell. I practice constitutional and international trade and public interest law. And we've prepared an opinion, as Barry's indicated, looking at the constitutional implications of Bill 32. And I'll take you through that in a moment. But before I get there, I just want to introduce the comments by pointing to a couple of the key features of the TILMA agreement itself. You need to understand what that agreement is about in order to understand its constitutional implications. And there are really two that are particularly noteworthy for the purposes of our assessment of the bill, which would implement the agreement. The first is the general prohibition set out in TILMA in Article 4 on government measures. And we know that under the agreement, governments mean municipalities, provincial governments, and boards and agencies and other public bodies in the province. There's a general prohibition on measures, in other words, actions or policies or regulations implemented by those governments or public bodies that interfere with or diminish in any way the rights of investors, labor mobility, or interprovincial trade. In our view, that's a broad and sweeping prohibition on virtually, certainly by some interpretations, everything that governments and public bodies do. Simply by acting, governments and public bodies intervene in the marketplace. They necessarily affect investment and labor mobility and trade, particularly in an integrated and Canadian and international economy. The sweep of the regime and the extent to which it applies to the actions of governments and public bodies is, of course, disputed by the province. The minister tells us it's only intended to catch discriminatory government measures, in other words, actions taken by governments that discriminate against investors or individuals or goods that would come into Alberta come into British Columbia from Alberta. But that's not what the agreement says. There are provisions in the agreement that speak about discriminatory measures. This broad prohibition set out in Article 4 doesn't. So in our view, it's very sweeping in its application, and ultimately what it means and how it applies won't be determined by Mr. Campbell or Mr. Hanson or even the legislature or his cabinet, but by private arbitrators, and that's the other feature of TILMA that I just want to briefly mention, and that is the right it creates to the benefit of individuals and companies and investors in Alberta, and of course vice versa, to claim monetary compensation against the people of British Columbia, where their elected officials or public bodies or agencies do what they are empowered lawfully to do, and what they may do entirely within the framework of their statutory mandates and within the Constitution. It's a way of punishing the people of British Columbia for the lawful actions taken by the people that represent them or that are appointed by the public bodies that are elected by them. Those are the two features that you need to keep in mind when you consider the implications of Bill 32. So to Bill 32 then, the bill implements TILMA. It sets out 16 amendments to provincial, it sets out various amendments to 16 provincial statutes. The most important of those amendments are amendments to and let me just get the name of the statute correct, the Enforcement of Canadian Judgments and Decrees Act. And in our view, that's the most important amendment because it provides for the enforcement of an award made by a TILMA tribunal. This is a private arbitral tribunal that's convened when an investor, for example, from the province of Alberta have some complaint about some public policy law or regulation that has been taken or implemented or established by a BC public body. An award by that tribunal is enforceable pursuant to this amendment to the Enforcement of Canadian Judgments and Decrees Act as if it was a judgment of a Canadian Superior Court. So the tribunals are authorized to award up to $5 million in monetary compensation arising from the lawful actions of public bodies in British Columbia. And you can take that award and file it with the Superior Court in BC, and it will be enforced by the sheriff, or however else you might enforce a judgment of a Canadian court under BC law. There are other amendments to provincial laws, particularly those that empower the cabinet to pass regulations that would override the statutory provisions of the statutes, the actual provisions of the statute giving cabinet the authority to make regulations. I'll come to those in a minute. The courts have described those as Henry VIII clauses because they arrogate power from legislatures to the executive of the government, and that was something that the king was fond of trying to do or get away with. And I'll come to those amendments in a minute. But let me take you through the four essential conclusions of our opinion. I'll do this quickly, and I'll try to do it in the vernacular rather than offer kind of the legal language and citations that you'll find in the decision if you have a chance to review it. I think in the simplest terms, the way to understand what the government's doing with this bill is that it's seeking to arrogate power. This political administration is seeking to arrogate power to itself from the legislature, not just the sitting legislature, but future legislatures, and not just legislatures present and future, but also from the courts, and in another respect, from the federal government. Yet the institutional arrangements between the legislature, the executive of a government, future governments and a sitting one, and the federal and provincial governments are relationships that are set out in the Constitution. By ignoring the boundaries that are defined by the Constitution, in our view, this bill challenges the very most fundamental norms of our constitutional arrangements in four respects. The first is that the bill amends two or three provincial statutes, the Cooperative Association Act, the Business Corporations Act, and I think the Financial Institutions Act is the third one. And those amendments give the cabinet the right to pass regulations exempting companies or cooperative associations from Alberta from the requirements of British Columbia law. The amendments also give cabinet the authority to override the provisions of the statute itself, and the amendments say where there's a conflict between the regulation and the statute, the regulation will prevail. Courts take a dim view of allowing the political administration of a government to, in a sense, assume what should be the proper prerogatives of the legislature to pass whatever laws it chooses from time to time to pass. And I wanted to just read you an excerpt from the way in which the courts have characterized this particular problem of overreaching executive authority. This is what the Supreme Court of Ontario had to say in a case decided in 1997, which is in our opinion, referring to a similar effort by that political executive. This breathtaking power to amend by regulation the very statute which authorizes the regulation is known to legal historians as a King Henry VIII clause, because that monarch gave himself power to legislate by proclamation, a power associated since with the 16th century executive autocracy.